second lecture of this series of lectures being given by Professor Anne Smith as part of the New Zealand UK Link Foundation Visiting Professorship. The Link Foundation spent a long time doing little things, bringing a student for this and a musician for that and a wine maker for something else. And then about 3 years ago, they sat down, 4 years ago, and seriously thought, what could we be doing to spend the money that came from the Waitangi Trust, originally in 1991, of which there's still quite a lot left. What could we do which would not only link New Zealand and the UK, but would have what we now call legacy? Because if we are investing in some form of academic exchange, the ideal thing would be is if after the exchange is completed, there is something that goes on and builds continuing relationships between New Zealand and the UK. And so we came, or the committee I was involved in, came up with the idea of, was there something more senior they could do rather than supporting students? Because as it happens, oddly enough, even in these rather straitened circumstances, support for students is one of the easier things to find. And I was then the Vice-Chancellor of the University of London, and they came to me and they said, Graham, do you have any thoughts about this? And we very quickly honed in on the idea that we would seek scholars, established research scholars from New Zealand who could come over, present a short series of lectures and have other interactions with the academic community, with the professional communities, with government, with a hope that afterwards there would be a set of contacts. And the first two professors who came over did just that. We had the retired speaker from the House in New Zealand, Margaret Wilson, who arrived just at the time that the British Parliament was worrying about matters concerned with governance and change, and she had very strong interactions with the select committees in Westminster. We then unusually had Professor Jonathan Gardner, who was a marine biologist, but he specialises in marine preservation areas, and very quickly DEFRA got interested in this, and now there's a strong series of interactions between the government people responsible for fisheries in Whitehall and Jonathan and his team. This year we have two visiting professors. We've worked on a very simple principle. If we don't get the right one, we don't bring one. And last year we had a not strong field, so we decided not to appoint and have two this year. The first of them is Anne Smith from Otago. You will know of her work and you'll hear more of it in a moment. The second, who's coming in the autumn, is an Anglophone Grimes, who is the independent chairman of the Reserve Bank, but also a professor in the University of Auckland. So it's starting to build that, and already we are finding that the discussions are not just in the academic community, quite the reverse. We've had immense support, particularly in Anne's case, from that community out there who are interested in the welfare of children and young people. She appeared with the all-party parliamentary group and talked to them. She's giving her series of lectures. This is the second. The work this evening is actually not being done by me. I just wanted to set the scene. The work is actually going to be done by my friend sitting on the left here, who is a professional. One of the things I learned in my years as a Vice-Chancellor was not to pretend that you're a professional when you're not a professional. Let those who really know and understand do that. And so we're fortunate in having Emeritus Professor Jane Fulton with us, and she will chair the evening. We will have a response after the lecture from Peter Newell, who is sitting in the front here, and then we'll have a free-flowing question and answer session. We don't get to this position by accident, and we owe thanks to a number of people, in particular Jenny Driscoll from King's, who has helped us immensely in setting things up. And without her, I think my assistant, Lisa, would have been in some considerable difficulty. But that's one of the nice things about a series of lectures like this. But that's enough. That sets the background. What you are actually here to do is to hear the lecture.
Well, I'm delighted to welcome on your behalf Professor Anne Smith, who, as you know, is here to talk about a topic of enormous importance to us all, and that is the physical punishment of children, the concept of their right to protection from punishment. And she's particularly well qualified to talk about that because New Zealand was the first English-speaking country to change its law in 2007 to prohibit parents' use of physical punishment on their children. So she'll be telling us about the research favouring that change and how the change came about and what lessons have been learnt in New Zealand from its introduction. And I'm sure Peter will tell us the way in which this legislation stands in stark contrast to our legislative position here. Just remind you that in 2007, the then Department of Education and Skills said of our law, the current legal position is clear and appropriate, but can be difficult to understand. It is neither correct nor incorrect to say that smacking is legal. Well, that shows how much we had to learn from New Zealand, and we're lucky to have an expert like Professor Smith to give us some hints over how to improve matters. Before she starts, I'd like to tell you a little bit about her background. Through her university teaching and research, she has a long and prestigious record of promoting the well-being and rights of children in their everyday lives. For many years she taught on early childhood courses at the University of Otago, and latterly it was her interest in children as citizens and social actors which led to a variety of research studies on children's perspectives, for example, their participation in classroom education. And in 2009, she was awarded the American Association of Orthopsychiatry, I think that's how you pronounce it, their Marion Langer Award for Research and Advocacy with Children. It was her record and interest in translating research findings into policies and practice for children, which led to her becoming the inaugural director of the Children's Issues Centre at the University of Otago. And it was that centre's very important review of the research on family discipline which undoubtedly influenced the move towards changing the legislation, the law in New Zealand. And she, I'm sure, will tell us about all that. The title of her paper is Changing the Law on Physical Punishment, Rights, Research and Policy, and I'd like us all to welcome her.
I just need to get my... Kia ora koutou, as we say in New Zealand, it simply means greetings to everyone, especially coming out on such a wet, miserable night. It's really a positive story that I have to tell you in my lecture tonight, following on from the first lecture, which was also pretty positive, I think. The story is not perfect or ideal, but I think it has some useful lessons about the links between research, policy and practice. So I just wanted to remind you of the underlying theme of the series of lectures I'm talking about. First of all, the moral imperative of children's rights and how that can make a difference to children's lives, and I'm hoping that I can give you some examples of how it has. Secondly, the role of research, and researchers can play in promoting reforms which enhance children's rights. I think that's some feedback from that. And thirdly, the importance of relationships and alliances and coalitions and collaborations, whatever you want to call it, between researchers, advocates and policymakers. So, as I'm going to be talking about physical punishment, I thought we had to start with a definition, and I wanted to make a distinction between punishment and discipline, because one of the things we have found is that a lot of people think it's the same thing, but absolutely not. Discipline is more about teaching, it's guidance of children's moral, emotional and physical development, but with the intent of them controlling their own behaviour, being able to take responsibility for it themselves. Whereas physical or corporal punishment is the use of force to cause pain or discomfort for the purpose of correction or control. One of the tricky things is the issue of definition, because there are a lot of people say, well, physical punishment is totally different from physical abuse. But in actual fact, there is a very fuzzy line between what is discipline and what is physical punishment and what is abuse. It's contested. There is no agreement at all between social scientists about what's abuse and what's punishment. The main difference is frequency and intensity. And as I said, no agreement amongst experts. It's very dependent on cultural values. And I found one US study that defined non-abusive spanking as 2.5 times a day, and abusive spanking is 6 times a day. So if you're someone who likes numbers, there's your dividing line. In some countries, including the UK, perhaps, and certainly Australia, where there are injuries to children, this is still considered reasonable chastisement. One of the things that Joan Durant has pointed out is that in one study, substantiated cases of child abuse were actually 75% of them started with physical punishment. So the issue is that physical punishment escalates very easily into abuse and harmful violence. That is not to say that even light physical punishment is not harmful. And I've just been reading a very good article by an Australian writer, Bernadette Saunders, who talks about physical punishment being a badge of childhood. She says physical punishment is arguably the prime manifestation of children's position in society. It is a clear badge of childhood because children are singled out as the only people who can be legitimately hit with impunity. And it used to be, of course, the case that domestic servants could be physically punished, cadets in the Navy or the Army were physically punished. It was regarded as acceptable for husbands to beat up their wives. Now we have only one group where that distinction remains. The issue of human rights is a prime consideration, and most of us would argue that you don't actually need research to show that physical punishment of children is inappropriate, because there is that issue of rights. And here you've got a quotation from Peter Newell, who's with us today, saying that it's now clearly recognised as a human rights violation, both internationally and regionally. But despite the almost universal acceptance of the Convention on the Rights of the Child, this is the most widely ratified treaty, I think, in the UN, 154 countries, isn't it? With only 2 not having signed it. These judgments are not still being implemented. And of course the Committee on the Rights of the Child is very active because every country has to report to the United Nations every 5 years, and they will make their observations about each country's report. And for the UK, it has been very clear for the last 3 reports that they've commented very unfavourably on the fact that the UK hasn't changed its law. So, as Peter says, adults are still resisting and delaying the realisation for children of a right that adults take for granted. And just quickly, what does the UN Convention say? Article 9, although it didn't precisely say, talk about corporal punishment, but Article 19 protects children from all forms of physical or mental violence, injury or abuse, and argues that measures have to be taken to prevent maltreatment. And the concluding observations that I just mentioned, and the same happened with New Zealand. We were told repeatedly that this was inappropriate. It was ignored. I don't think the UN's deliberations would have changed things on their own, but they were influential. And the general comment number 8, which was published in 2008, is absolutely clear about the inappropriateness and the violation of children's rights that physical punishment is. It's interesting, a couple of new general comments have come out recently from the UN, and I like the way that language now is reflecting the theory that some of you in this room are working with in childhood studies, and they talk about a paradigm shift in the way that we view children, and that's true of the early childhood general comments as well. And also the other interesting thing about the general comment, apart from its clear explanation that corporal punishment is a violation of rights, is that it says you've got to see the convention as a whole, and you need to make links to Article 2, which is about not discriminating. Of course, it's a clear discrimination that children are the only group that are physically punished. Article 3, which is about the best interests of the child. Article 6, which is about children's right to survival and development, and as I shall show you, physical punishment is a threat to their survival and development. And Article 12, which is about consulting children on matters which affect them. And Pete Newell has pointed out to me that there's another new general comment, 2013, which it is about health, but it also, on the grounds of the harmful effects on children's health, points out the obligation to eliminate physical punishment. So before 2007, our law in New Zealand was very similar to your law here. It's based on English common law, which in turn is based on Roman law. And Section 59 of our Crimes Act in 1961, it was later amended in 1990, parents were justified in using force to correct a child if the force used was considered reasonable in the circumstances. Now, the language is slightly different, I think, from your own legislation, but not too different. I think you talk about reasonable chastisement, which is a very archaic sort of word. In New Zealand, before the law change, that defence, which is really an excuse in law, allowed parents to be acquitted, and it was very, very unclear, as James pointed out. Sometimes you could you could be not acquitted, but they were successfully defended for hitting a child with a bamboo stick, a belt, a hose pipe, a piece of wood, or putting a child in chains in one case. So that piece of law allowed parents to assault their children because it was considered discipline. Now, in the academic world, the work on children's rights comes together very closely with childhood studies, which is a somewhat new paradigm of childhood which emphasizes the following things. First of all, children's agency. That is, that children can initiate. They're not just the objects of what adults do to them. They make choices, they make decisions, they do things, they take responsibility. So childhood studies emphasizes children's agency and their right to participate, to be members of society. Their status as subjects, not objects, persons, not possessions. And of course, a lot of the arguments against changing the law are based on the fact that we'll do what we like with our children. They belong to us. And childhood studies problematizes that approach. So, second thing about childhood studies is it says that childhood is not a universal phenomenon, that it is actually culturally and historically situated. So, the way we think about childhood in New Zealand may be quite similar to what you think about it in the UK, but in some respects it may very well be different, and there are clearly very different ways of thinking about childhood, even within New Zealand. Within Maori and Pacifica cultures, there are different understandings of what it is appropriate for children to do. And for one example might be, in Pacifica families, children are not expected to answer back. They're expected to listen to their adults and not take so much agency as we now expect our children to do. Now that's a big generalisation, and it's changing in Pacifica cultures as well as it is in our culture. Another thing that comes from childhood studies is the idea of the importance of generational relationships, the relationships between generations, and how that is played out in the way that we interact with our children. So that now we're less likely to expect children to be instantly obedient and to do exactly what they're told, to be seen and not heard. So there is more democracy. Children are expected to play a part in family decisions. So the relationships between generations are changing. And of course, in the use of physical punishment, the old, more traditional ideas of children being the objects of parental discipline is being questioned. Children are not expected anymore to be the passive recipients of punishment. In relation to, just going back to the point about generational relationships, those also are embedded in cultural and historical times. So we have views about the appropriate power relationships between adults and children, and those are sometimes very strong barriers to reform. And the general comment number 13 actually says that decreasing violence in one generation will reduce it in the next. So another thing that comes from childhood studies is the idea that we should pay attention to children's perspectives on things. We should listen to their voice. And James Garbarino, who's a very influential American psychologist who works a lot on violence against children, says that the power of children to articulate their experience has a an important role in actually changing the way that we see what's happening to them. And I'm about to try and show you a video. So seeing children's physical punishment from the child's perspective is a powerful tool for sensitising adults. Now let's see. So I just want to show you so you can have a look at what some New Zealand children say when they're asked how they'd like their parents to talk to them.
Talk nicely and clear up like you. I like it when they speak softly. I don't like people to scream. And if you don't speak to them nice, they won't speak to you nice. The don't like it. Don't go too angry. Speak nice. Being friendly. Respect other people. I like the happy wreath. Tell you the right things to do and not the wrong things. Well, they show me what to do because I sometimes can't see what they're doing. Tell me what I should be doing. Help me do it if I'm feeling cross. They should hear me too. And I'm 4 years old now. They give me choices that are right and then I choose them. Like I'm shopping and getting some things that I really like. They take me somewhere to play and take me somewhere with my friends. Give them a toy, watch television, give them a new pet.
Now, this is interesting.
Love,
this is
respect,
older
and
children.
trust are the most important things. I mean, being harsh isn't going to help the situation, isn't going to change any mistakes that he's made or she has made.
The best way for a parent to show their teen that they still care and love them is, just to be interested in what they're doing, and it's just the basic things, but even though they're basic, it's a real big impact on the teen.
Sometimes I get a bit sad when I know that they're like busy and they never really have time for you, and it's just good that they don't have to be at work all the time or have chores, so that they can just sit down and relax and just enjoy it.
Just talking about things that are going on in my life and either going shopping or just playing games together, and that's very important to me. I cherish that time that I have with my parents doing that.
Their lack of pride in me, like if I do something stupid or wrong, they'll tell me they're disappointed, and they will tell me that I've done something wrong and I have to fix it. I have to take responsibility for what I've done.
The worst thing, or at least in my case, I can do to my parents is actually disappoint them, because I don't want to do that. And that's probably the best punishment which can be created.
That video was made by a group called SKIP Group, Strategies for Kids and Information for Parents. And it's quite interesting because that existed before we changed the law in New Zealand, and there was this belief that you could help, that we used the video to try and educate parents about ways to interact with children. And I'm not suggesting in any way that this is the only way that can be done. And certainly I'm absolutely with Peter and other groups saying that you have to change the law first, or at least at the same time as educating parents. But that video is very powerful. There's a lot more to it. I just showed you a little bit there. But it's the Ministry of Social Development that funded that. Now, where's my... sorry. So I'll talk a little bit about the research on physical punishment, and obviously I can only do it fairly quickly here. But I worked together with Joan Durant, and we wrote a book about the abolition of physical punishment, and we told the stories of 19 different countries that have either changed their legislation or tried to change it, or are in the process of trying to change their legislation. And she argues, and this is, I think, important, that there are three forces that have been important in changing the law: the research, the Convention on the Rights of the Child, and law reform. And she says they have altered the landscape of physical punishment. When she wrote that, there were only 31 countries that had banned, but now 33 have. Okay, so just briefly to touch on some of the research, and there is a lot in our book, but also many other places and organisations have published some of this research. One of the main reasons that people use physical punishment is that they want children to do as they're told, to comply. And in a big meta-analysis, there were 5 studies, and it did show that there was 3 studies showed an increase in compliance. One study showed no relationship, and one study showed a decrease in relationship in compliance. So not really a very strong argument, but the problem is that the compliance that is achieved with physical punishment is not internalized compliance. What is very clear is that there are some unintended consequences, long-term, or medium-term, I suppose you could say, of physical punishment. 12 out of 13 studies in the Gershoff meta-analysis showed that there was an increase in antisocial behaviour, aggressive behaviour, disruptive behaviour, externalising behaviour associated with physical punishment. Just before I discuss the third bullet point, generally the research shows a linear relationship. That is, the more frequent and the more severe physical punishment, the more harmful the effects are. But there are now 1 or 2 studies that are showing that even light and infrequent use of physical punishment is associated with undesirable side effects. One project by Bouchain in 2005, which was actually able to show a causal relationship, but of course it's quite difficult to show a causal relationship because you can't randomly assign children to a punishment and a non-punishment group, which actually showed that a parent education program had the effect of decreasing the amount of physical punishment that parents used, and then that had the effect on reducing children's aggressive, antisocial, externalising behaviour. Mental health problems, depression, withdrawal is very much part of the literature on the research on physical punishment. Interesting one, those of you who work in the early childhood education area, heightened levels of cortisol in the brain, and cortisol is something that affects the architecture of the brain, and the fact that they were able to show physical punishment associated with high levels of cortisol, which actually reduces the efficiency with which children are able to cope with stress. And delayed cognitive and language development. And Joan Durant and I have speculated that because parents aren't using language, aren't reasoning, children aren't able to explore in the same way when they're in families with low physical punishment. That affects them cognitively. And very, very clearly, disrupted parent-child attachment. That is, not a trusting, secure relationship between parents and children. And I always like to quote, because there is a huge amount of quantitative research in this field, a qualitative study which gives you a bit of a feeling about why the attachment is disrupted. And there's a quote from a woman who says her mother used the wooden spoon her father was into bare hands. If you were naughty, they took it as a personal affront. she was basically very good, and she was hit frequently. She thought that being hit made her do silly things. And the message she got was not that what you're doing is bad, don't do it again. The message I got is we don't love you. Now, a lot of that research that we are using in making arguments to abolish physical punishment would be very much criticised by childhood studies scholars, because mostly it treats children as the passive objects of parental discipline. Nevertheless, we still use it. And I think it is still useful to use this argument. So I know that Joan, for instance, Joan Durant, has said that this sort of research constructs children as passive recipients of parental authority. There are some very interesting studies, and I've just quoted one New Zealand one who was a student of ours, Terry Dobbs, where we talked to children about physical punishment. And in the UK, Carolyn Willow's done an excellent research study like that. And we talked to the children, and they talked about being hit with spatulas, tennis rackets, spoons, belt, feeling sad, angry, unloved and scared, punished by many family members, not just one. And really a very big majority of them talked about being physically punished. And here's a couple of quotes from children. This is from Carolyn Willow's study. The child says, "If they don't change the law, oh well, the child doesn't mind, we'll keep on doing it." I think that's a great quote, actually. And here's an Australian child who says, "Adults have more power. They can get really mad and swear. Children can't do anything because they don't have enough power. We have to do what they say. Adults can hurt them." So this kind of research was important in New Zealand. My centre was commissioned by the Children's Commissioner, the Office of the Children's Commissioner, to do a very comprehensive literature review, and we reviewed over 300 studies. And the government helped us to disseminate those findings by having a free report that went out to any parents. There was a lot of cooperation before we did the literature review. Government officials were able to say, well, look, we want to know the answer to that question, and I think that was important. We produced reports, there was a lot of publicity about it, and for the first time in my life I got hate mail, and I'm sure others of you who are advocates in the physical punishment field will have recognised that, because there is the opposition. And there was a very effective campaign by people like Peter Newell. The prime person in New Zealand was a woman called Beth Wood, and she just simply was there all the time, making sure that politicians were made aware of a lot of information. Now, SKIP is a program which was designed to help parents, but although it's a very good program, it's very uneven. So this is just quickly what happened. How did it happen? I mean, it was drawn by ballot as a members' bill, and it only just got through its first reading. The Labour Party was in power at the time, but they weren't really pushing it. The bill went to a select committee. Now that was a really important process in New Zealand, because in the select committee, there was almost a whole year, people made submissions to the select committee, and there were individual and group submissions. So for instance, the Children's Issue Centre made a submission, many universities did, professionals like paediatricians, social workers, family lawyers, all of these people got a hearing in the select committee, and a lot of them got publicity in the process. I think that really changed a lot of minds, even though there were many individuals who were very, very strongly opposed to changing the law. The fact that those reasoned arguments went before all of these members of Parliament, who might not have been too convinced to start with. When the second reading happened, there were 70 in favour and 51 were opposed. So it proceeded to a committee of the House, and there it went through a line-by-line debate in the House. And we hit the Easter recess, and then there was a lot of behind-the-scenes discussion between Sue Bradford, who was the Green Party member who'd introduced the bill, the Prime Minister, Helen Clark, who took a lot of leadership in this situation, and the Leader of the Opposition, John Key. And there was a lot of negotiation. Sue Bradford steadfastly refused, and I really applaud her bravery in this. She refused to negotiate at all on issues like which part of the body might be able to be hit, might be legal and illegal, because there are places where, you know, it's only illegal to hit children on the head, say, or to make it illegal for children below a certain age, say under 2-year-olds. She refused to talk about, to negotiate on that. But what they did negotiate on was something which was easy enough to give way to, which said that the police had discretion as to whether they prosecuted or not, which they had anyway, but it was easy enough to put it into the law. And so there was opposition, and still very controversial, particularly strong Christian opposition, but the mainstream churches were very much in favour of the legislation and spoke out in favour. And what people who were supportive, Commissioners for Children were really, really supportive. The non-government organisations like, well, I guess EPOC New Zealand and Physical Punishment of Children was the strongest, but there were some other really strong groups like the NGOs and UNICEF, Save the Children, and Plunkett Society, which is our child health organisation. And professionals, paediatricians, teachers, family lawyers, social workers, and mainstream churches. And I might say, I haven't put that on the slide, but leaders of the Maori and Pacific groups too. And that hasn't always been the case. Oh, I did have it. So the bill passed into law in May 2007, and there was a cross-party agreement. Because of that behind-the-scenes negotiation over that Easter recess, the vast majority of the MPs voted in favour, and they were allowed a free vote, I think, yes. And only 8 opposed it. And I don't remember each one of the 8 that did oppose it, but one of them was Winston Peters, who's the leader of a small but powerful, and likely to be even more powerful at the next election, party called New Zealand First. So we became the first country English-speaking country to ban all physical punishment of children. And this is, I haven't put the total wording in there, but it does say very clearly, nothing in subsection 1, which gives a number of exceptions, or in any rule of common law, justifies the use of force for the purpose of correction. So subsection 1 describes situations where force may be used. For example, if a criminal offence is about to happen. So that's all good. It's a good story. But the bad part of the story is that we didn't do what they did in Sweden. We failed to educate and explain why the law needed to change, why children were at risk, why it was violating their rights. So the general comment number 8 argues for comprehensive awareness raising of children's rights to protection and of the laws that reflect this right. We didn't do that. We had that SKIP program, but it was pretty small and uneven, and I don't think it really got to the parents perhaps who could have benefited most. So the New Zealand government really, when they passed the law, they just wanted it to go away, the discussion. They just didn't want any further controversy, and that's still the case, I think. So when Sweden changed their law, very long time ago, they started to do it in 1959, they got rid of the defence, it was on every cornflakes packet. why they were changing the law and what was the rationale behind it. And there was a lot of support for parents and parent education. We didn't do that. Even the NGOs, the people who really supported the legislation, are quite nervous of allowing it to become a cause of more discussion, because they're afraid that that will, well, the Let Sleeping Dogs Lie explains why they don't want to raise it anymore. So what happened after the prohibition? Well, there have been a number of surveys, and I'll just quickly go over these. There's been a question asked, originally in 1981 by James and Jane Ritchie, which says something like, would you think that the use of physical punishment is ever justified? And in 1981, something like 87% of people said, yes, there are some situations. In 2007, that slide is a little bit misleading. 2007, 58% said there was some agreed that there were some circumstances that could use physical punishment. But the most recent one that has just been done in 2013 showed that it had gone down to 40%. Now, that might not seem very positive, but it's a big drop-off in the number of parents who are saying that it was ever justifiable. We found in a study in 2008 that about half of the parents we talked to, and it may not have been, maybe they wouldn't have talked to us if they thought they knew what we felt about it, they were in favour of the legislation. Interestingly enough, a lot of people didn't really understand it, and the ones that did understand it were more likely to support it. If they didn't understand it, they were more likely to be against it. There was a big, I think it was something like 5,000 parents, Ministry of Health study, and that showed that 4.5% of parents had used physical punishment in the last month or something like that. So it was a very low level of use. However, a very sad story was that we had a citizens-initiated referendum in 2009 that was initiated by a former politician, Baldock his name was, and a very loaded referendum which said, should a smack as part of good parental correction be a criminal offence in New Zealand? And 87% voted no, sorry. However, there was only a 54% turnout, and it was a very badly worded referendum. The other thing that's happened, there have been reviews by the police and by the Ministry of Social Development. All of them have shown, well, they don't say very much about what good it might have done for children, but what they do show is that fears that this would criminalise parents or be excessive state intervention into family life were not realised. In the latest report, which just came out, there were 355 child assault events, and 12 of these were smacking, which meant on the bottom of the arm. 31 were minor acts of physical discipline, and I've quite forgotten, but it was more than just a slap on the bottom of the arm. And 252 were child assaults. So there was no defence for assaults anymore, and 60 were no defence was disclosed. That none of the smacking events were prosecuted, but 9 minor acts of physical discipline were. They nearly all involved children being hit around the head. And the results were that generally they would give supervision orders, or they were sent to a violence prevention program, or they had to do community service. So they were all that sort of thing, community work, suspended sentences and so on. So there was no evidence that there was any great change in family life. Now this is an interesting study that a colleague of mine, Julie Lawrence, and she warns me that this is very preliminary data, but I think it's so interesting she allowed me to talk about it when I'm here. This is a big study being done at the medical school in Dunedin of 805 families where they've had data from birth. And at when the children were 18 months, parents were asked, do you currently avoid using any discipline practice with your child that you experienced during your childhood? And about a quarter of them said yes. And of those ones that said yes, 75% of them said they would avoid physical punishment for a variety of reasons, but one of the main reasons was the legislation. And also they said they felt terrible when their parents had used it, that I remember feeling hurt and angry, they said things like that. Others said it would just frighten the children, which isn't the point. So they talked about harmful effects on children, they talked about how much they hated it, and they talked about the legislation. So the legislation was there in their minds. So does legislation make a difference? There's a chapter in our book by a German research team, Bussmann, I can't remember his first name, but he did cross-country comparisons and showed that countries with legal prohibition had less violent parenting and more negative attitudes to physical punishment. So Austria, Germany and Sweden compared to France and Spain. And so that's quite a detailed study, and that's just a highlight of it. He also found, or that German team also found, that when there was legislation, that when there was publicity and education alongside the legislation, that it was more effective. So, 33 states, and there's the full list. And these two countries have Supreme Court legislation. It's not in legislation, but Supreme Court have ruled it illegal. And there are 21 states committed to prohibition, and Peter Neal will know a lot more details about that. 142 states have no commitment. So to conclude, first of all, I feel really positive about New Zealand having made some progress towards implementing Article 19 and children's rights, and I think it's a really important first step to reducing violence towards children. And these were some of the factors that came through as allowing this change to happen: the United Nations Convention, commissions for children, advocacy by NGOs, input and dissemination by researchers, the support of professionals and mainstream churches, and leadership from politicians. I think that last one was really, really important. Although there was an element of luck in it, because it was a members' bill drawn in a ballot, the fact was that Helen Clark was a very strong leader, and Peter tells me that she came to Westminster and spoke to politicians here and said it was one of the most important things that New Zealand, that she had achieved as Prime Minister, or her government had achieved as Prime Minister. So attitudes and practices are changing, and but in my view that we need a lot more public education and more parent support. So, and finally, the other thing is, because I know the Labour Party was saying this at the beginning, first of all we need to change attitudes and then we'll change the law. But I totally agree with Peter that it's important to change the law first, and then the attitudes will change with it. Thank you.
Well, I'm sure everybody like me found that absolutely fascinating, and certainly particularly interesting to hear about the outcome afterwards, and the need for education programs. It sounds a really important aspect of changing any law. I'd like now to introduce Peter Newell, who's here representing UPOC. As you, I'm sure, all know, Peter and his colleagues have worked tirelessly to achieve a change of the law in this country. He's enormously knowledgeable on this topic of law and social policy, and so is very well placed to respond to Professor Smith's paper. So welcome.
Thank you very much, John. Well, thank you, Anne, for giving us such a clear account of what has happened in New Zealand, and also for your long-term work on disseminating the findings of the completely devastating impact that physical punishment does have on both children and societies. As you say, states have an immediate human rights obligation to both prohibit and eliminate all corporal punishment, all physical punishment, irrespective of the harm it causes. But research into its prevalence and also its impact is, of course, hugely useful in advocacy. And I'd like also, because I think you were a bit coy about it, to draw attention to Anne's book, which she edited with Joan Durrant, Global Pathways to Abolishing Physical Punishment. It's a very good, detailed account of what's happened in 19 countries. So, I'm afraid that hearing about New Zealand's success fills me with completely unconstructive anger at the hypocrisy of successive governments in this country who pretend to support children's rights and say they support children's rights and ratified the convention a long time ago, but yet still pick and choose which rights to respect and which to ridicule. And there's fundamental right to equal respect for children's human dignity and physical integrity, and to equal protection under the law is one which they tend to ridicule, the previous government and the current one. And really, I ask, how can we expect children to take human rights seriously, to help build a culture of human rights for the future, which is what we all want, when they see adults endlessly hesitating and delaying over putting right such a completely obvious wrong, such a blindingly obvious violation of children's rights. If hitting people is wrong, and I doubt if anyone would disagree with that, then hitting children is doubly wrong. It's not a complicated issue at heart, and it really is only adult hypocrisy that keeps it controversial in reality. As the Committee on the Rights of the Child states in its detailed General Comment number 8, which Anne quoted, the dignity of each and every individual is the fundamental guiding principle of international human rights law. And clearly there is no dignity in hitting children. Parents know this just as well as children. Smacking makes almost all parents feel bad and guilty. And we're not doing parents any favours by maintaining this archaic defence of reasonable violence. Everyone, not just children, benefits when the law is clear and unambiguous, and we accord to children exactly the same protection against being assaulted, which we take for granted for ourselves. Some suggest another, to me, adult diversionary tactic, that this is too trivial to merit the attention of serious government in these hard times. Well, that's insulting to children too. This issue, anyway, doesn't compete with other issues. It is simply removing a gross anomaly in law and policy which treats children as possessions who can be hurt with impunity rather than people and rights holders alongside the rest of us. Across the UK now, the Children Are Unbeatable Alliance, it started as EPOC and it's now termed the Children Are Unbeatable Alliance. It includes more than 600 organisations and projects and many prominent individuals advocating for a complete ban on smacking, complete removal of the reasonable punishment defence. It's the largest alliance ever established in the UK to pursue an issue for children, and it was formed in 1998, launched at the NSPCC, when we believed, sadly, naively as it turned out, that a European court judgment condemning the ancient reasonable chastisement defence would force the UK government to legislate to ban all corporal punishment, including in the home. And at that point, just 7 states in the world had banned all corporal punishment. Now, as Anne told us, there are 33, including 5 in Africa and 3 in Latin America. The European Court judgment, A v UK, was about the severe and repeated caning of a young boy by his stepfather, who was prosecuted for causing actual bodily harm. He used the reasonable chastisement defence, and he was acquitted in a Hereford court. The judgment, which found that the boy's right to protection from degrading punishment had been breached, and the UK government was responsible because its law allowed reasonable chastisement. We hoped that that judgment would, and it did, at least force the UK in 2004 to legislate to reduce the scope of the defence, to prevent it being used to justify actual or grievous bodily harm. A complete ban was a step too far for Tony Blair, who told MPs who visited him the night before the crucial vote that while he and Sherry's views had changed and they were not smacking little Leo, it was still a step too far to allow a free vote on this issue in Parliament. So parents and some others in England and Wales and also Northern Ireland can still justify common assault as reasonable punishment. Scotland maintains the possibly more honest defence of justifiable assault on children, and it defines as unjustifiable shaking, blows to the head and use of implements. So since then, since 2004, successive UK governments have defiantly resisted repeated calls from both international and European human rights monitoring bodies to fulfil their obligations under the Convention on the Rights of the Child and other instruments and remove this defence completely. They've had calls from the Committee on the Rights of the Child 3 times, and there'll be another coming up next year, from the Committee on Economic, Social and Cultural Rights twice, CEDAW, the Committee to End Discrimination Against Women once. We're expecting one from the Committee Against Torture, in fact, this week. And also European bodies have repeated the same recommendations. And in the Universal Periodic Review, which looks at states' overall human rights record, both the first and second cycle, the UK has received repeated recommendations from other states. Well, to be a bit more cheerful, at least for a bit, there is some hope now in Wales, which has to be strongly pursued. By 2002, the Welsh government had developed its own policy, distanced from the UK government, seeking a complete ban on smacking. And when the disreputable compromise allowing reasonable violence against children went through our Parliament at Westminster in 2004, In Wales, the then Children's Minister expressed the Welsh Government's deep disappointment, and the National Assembly voted by an overwhelming majority to regret the retention of the defence. In 2007, the UK government was forced to include in its periodic report to the Committee on the Rights of the Child confirmation of the Welsh government's support for a ban, and this was noted by the committee in its concluding observations in 2008, together with the fact that Wales then lacked the devolved power to legislate. And in the same year, the Council of Europe's Commissioner for Human Rights, on a formal visit to the UK, acknowledged the distinctive commitment in Wales to ban smacking, and he deeply condemned the UK government for its lack of action. Now, 18 months ago, in October 2011, the First Minister in Wales confirmed that it does now have the devolved power to legislate after another devolution settlement, and a strong cross-party majority of Assembly members voted then to urge the government to introduce the necessary legislation. So now, at long last, there is a real opportunity for a breakthrough in the UK, and I can't overestimate the significance of that. It's the first time there has been a clear cross-party majority for banning smacking in any legislative assembly in the UK. And now there is a bill in the National Assembly focused on social services and well-being, and including provisions on safeguarding children. English babies could soon be crawling towards the border for protection. But sadly and ironically, the minority Welsh Labour government, now it has the power to do this, to ban smacking, has got cold feet about using that power, and seems to be trying to erase the last 10 years of commitment of previous Labour governments. The Children Are Unbeatable Cymru is campaigning hard, and hopefully there are sufficient AMs with integrity and respect for children's human rights to finally discard this concept of reasonable punishment from at least one part of the UK. Wales was the first part of the UK to ban smacking in early years care. It was the first to include physical punishment in its definition of domestic violence. It was the first to appoint a children's commissioner. And, perhaps most significantly, it's the first to place in legislation an obligation on its ministers to pay due regard to the Convention on the Rights of the Child. And you would think that that alone would persuade the current government to actually do this. So how can we tolerate, how can children tolerate further delay, more adult excuses? It's quite obvious that this is never going to be an easy achievement for any government. It certainly wasn't easy in New Zealand. And as on many issues of human rights and equality, legislators have to lead, not follow public opinion. And here they have to do so on behalf of an unenfranchised minority. We can be sure, of course, that there will be loud Daily Mail-style opposition, a vocal minority, as in New Zealand, of fundamentalist Christians trapped in an Old Testament world, spare the rod and spoil the child, and organised here by the Christian Institute, will make a big fuss about this. But in Wales, the Archbishop of Wales and other prominent faith leaders are very strong supporters of a ban. There have already been 2 prayer vigils in Cardiff and Brecon to support law reform there. So I hope that any of you with Welsh connections will please get involved in this fundamental campaign, And I'm very glad that Anne will be addressing the cross-party children group in the Assembly next week. So thank you again, Anne, and thank the New Zealand UK Link Foundation for bringing you here. We just hope that we can soon achieve what you have achieved in New Zealand. Thank you.
Well, thank you, Peter. That was a passionate plea for us all to try and do something about the sad state of our world here. We have got nearly, 20 minutes, I think, to really open up the whole session to people who've been listening quietly up to now. I'm sure many of you have got some questions, some points to make. So please, now is your opportunity to ask questions of either of these two speakers or to make some points of your own. Would anybody like to start the ball rolling? Would you like to give your name and where you're from?
My name's Maureen Newby and I live here in London. I'm very interested in the fact that this law was passed in 2007. And I'm looking at the question of what's happening in schools. Punishment, I think, as I've understood it, is the laws in respect of parents.
Yes, it was banned in schools in 1989.
That's fine. I just wanted to make sure that that was something that was... So that is happening. Your other point was about education and of parents and it not really keeping up with the law. So the law is there. What's being done about that? Because I think that clearly here, education is key. Parents need to be educated. Change will come from them, in my view.
Well, not enough. Not enough is being done. Oh, I've got a long time actually to be working. And I think that we can learn from some of the campaigns. I don't know if any of you have seen the Welsh Children Are Invisible. Peter sent me a link and it's fantastic. It's got the Archbishop, the Commissioner for Police, a variety of very influential people as well as children. It's really just short but very convincing, and I certainly came away from talking to Peter thinking that I'd like to go back to New Zealand and see if I can find the funding to do something like that. Just a very short film, which, you know, we don't need to change the law now, but we do need to explain it still. So I'm very passionate about that, and I'd like to see that happen. In several other policy things that I've worked in, I find that film is very compelling. That's why I like that little clip of the children there. You know, the thing about a picture is worth 1,000 words, and I think that just hearing different people's views, and if we could get someone like Peter Murrell or Joan Durant, who's just fantastic. I failed to mention that, but before we changed our law in New Zealand, Joan Durant, who's a Canadian professor from Manitoba, and a wonderful speaker, came, she talked to Parliament, you know, she was at breakfast at Parliament, and she just really convinced a lot of people, so it's absolutely essential, but we've stopped doing it now, and I think probably we have to go back and do more.
My name is Ros Kane, and I partly run a charity called Carefree Kids in East London, and what we're trying to set up is a course for teenagers at school, male and female teenagers, a course about how to be a good parent in future. It's not for teenage parents particularly. And this sort of thing has been done in the States, but in this country I don't know anybody who's been doing this in terms of the emotional health of children. And we're hoping to start in a small way in September. And there's a leaflet here called Parents Under Construction, which gives details of what we're doing, and we're inviting people to get in touch with us if they'd like to talk about it. Well, yeah.
Driscoll from Charlestown is at King's. I was just wondering, what's the position in New Zealand about educating children as to their rights? Or is that regarded as inflammatory to teach them their right to protection from that kind of
Yeah, that's a good question. Well, we do, my husband John, who's teacher educator, probably know the curriculum better than I have, but we have citizenship in the curriculum, and I'm pretty sure that you get taught about your rights and responsibilities. I don't know that there's a lot really done in schools, but there is some interesting research, I think, in this area where teaching children about their rights is a very effective way of getting them to understand other people have got rights too. I don't know whether you've come across Catherine Covell's work in Canada, another Canadian, working a lot in schools, and yes, I think it's very important. I like that. I think when children grow up understanding their rights, Peter, I'm sure, will comment further, there's much more chance that it's going to be everyone understanding about rights and making sure that they get looked after.
Yes, Catherine Covell's worked here too, Rights Respecting Schools project. I think it started in Hampshire, but it's spread around. And of course, the problem sometimes is it's difficult to teach children about rights in a setting in which they don't necessarily feel their rights are being respected. But it's obviously important. Part of the rights of children and young people measure in Wales, which requires ministers to have due regard to the convention, also requires them to educate children about their rights. I'm not sure how much is happening yet, but that's a specific, it's a legal obligation in the convention, but it's very important to put it in domestic law too.
I was just thinking about, in a way, teaching directly about rights may not be the best way to go about it. It's actually implementing children's participation rights in educational institutions that might be most effective. And I think we're very good at that in early childhood, and maybe in primary education in New Zealand, perhaps a little less so. But that's just a gut feeling on my own. But our curriculum very strongly in early childhood reflects an understanding of rights, I think. And therefore, hopefully children absorb that.
My name is Mariela Navek, I'm from Romania, and I was involved in the reform of child protection there, change of legislation, and of particularly reforming institutions for children. Physical punishment was banned by law in 2004, and with financial support from the European Union, we had 2 national campaigns. One was specifically on better parenting, with pretty good TV spots and all the rest of it, and it was appreciated by Professor Pinheiro when he was in Romania in 2007 or 8. I think it is very important, however, to show parents the alternative, because I thought it was very important that children were asked what kind of reward they expected. I don't know whether they were asked how do they expect parents to react when they have a conflict. I'm sure children can come up with very good answers, not of course when they're in conflict, but that can be done through groups and getting children involved and getting parents aware. I think a lot of politicians and a lot of parents, and politicians are parents as well, simply fail to communicate and lack the knowledge. And I think this is as important as changing the law is. And efforts to do that are important as early as possible, with or without political commitment of those in government. Thank you.
Can I just, I mean, of course, both are important. Changing the law without any public education would not achieve much. But I think it's fair to use the parallel of violence against women. And no one would argue that we should wait before prohibiting all violence against women while we introduce universal anger management courses for men or full employment for men. I do think that the problem is that when it comes to children, we forget that they do have an equal human right to this protection, and it's an immediate right. And of course, what we should do, we should have done years ago, is change the law, and also, as in Sweden, put a lot of investment into telling everyone what the law now says, that it's equally unlawful to hit a child than anyone else. Also telling them that corporal punishment is very dangerous and a bad thing, and giving them suggestions of positive ways of bringing up their children. I don't think it has to be very complicated. I mean, it's, you know, it is how we expect to be treated ourselves, and there is this awful traditional pressure on parents to use smacking, and I'm afraid still in supermarkets the pressure tends to be to smack rather than not to smack, although I think that is changing even in this country now. But people seem to forget that the law is, you know, like any good law, its primary purpose is prevention. Its purpose is not to prosecute more parents. That's much too late for children. Good law is about prevention, in this case preventing assaults on children. And of course the effect will not be that parents will be charged and prosecuted for trivial smacking, because that doesn't happen with trivial smacking between adults, and there are hurdles of public interest and children's interests that have to be got over before any charging or prosecution goes ahead. But I've got very impatient with people thinking we should educate first and then change the law, because again it's completely denying children's status as rights holders.
More enabling again, so to ask another question. Can you, Mr. Hill, give some indication as to why there has been such resistance from the government to implement the UN Convention and Article 19? Why? What's behind it? It doesn't make any sense to me. It's plain and simple. You just do what is necessary. I don't get it. Never have.
Well, I think it's not popular with the public, and we've had governments that have governed on the basis of focus groups for some time. And because there is, children they are unenfranchised, if that's the right expression. They don't have a very powerful lobby working for them.
We've got commissions.
Well, we have children, yes, and they're just about to be given a proper focus on children's rights in England for the first time. They don't. In Wales now, the Commissioner is speaking pretty strongly on this issue, I'm glad to say. But generally, the Commissioners, they have made a statement that they support law reform, but they haven't made it a priority because they know it's deeply unpopular with both the previous Labour government and the coalition. It is Liberal Democrat policy, a complete ban, but it's not an issue that they're going to twist the arms of the Conservative Party with at the moment. I think it's, I think it's crazy because so many of the aspirations of government will not be properly achieved while they maintain this attitude to children and this particularly symbolic reflection of an attitude to children. How can any country think it has an effective child protection system when it has lawful violence against children, which we all know escalates into dangerous violence? It's crazy.
I think there was somebody at the back and then somebody in the front.
Thank you very much. My name is Claire Coghill and I am a lead member for children and young people in a London borough. But I also work with the former chairman of the Education and Skills Select Committee, so I'm immersed in these issues all the time. I think for me, hopefully a campaign will be successful and Wales will be the first step. I think the Daily Mail point that you made is very, very relevant. I think for me there were a number of things at play that need to be overcome as part of this, what will be hopefully become a successful campaign. For me as a lead member, something that I've observed is that the social care profession and social workers generally are so ground down, so denigrated and derided in this country. And I'm not one, I speak merely as an observer, that this sense of outrage that we feel intermittently when a child dies is a mockery of the fact that we undermine and humiliate people who work and dedicate themselves totally to the care of children the rest of the time when those very severe cases aren't making the headlines. And I just think there has to be something around rebuilding the prestige, or maybe for the first time arguably, building the prestige around those people who do stand up for children, whether they're in the voluntary sector like Ros, or whether they're our social workers in our care system. Because I feel as though when I'm working in Parliament, these issues of social care just isn't talked about. If I'm honest, and I stand here, I speak of my own party as well, they just aren't talked about in the way that they need to be. And I also feel really strongly that the word smacking needs to be eradicated from this debate altogether, because it doesn't convey the gravity of the situation we're talking about. And just a final point, in all of the briefings that I had with officers when a year ago I took over this portfolio, I asked all of them, social workers, youth workers, people working with young offenders, what's the thing, if you had a magic wand, what's the thing that you could take away that would have stopped the damage to these children in the first place, or that could give them some kind of hope for the future? And the unifying factor that everybody talked about was domestic violence, very specifically violence against women and girls. That was the thing that was talked about relentlessly. And I think the debate needs to really focus on that we don't tolerate violence of any description towards anybody. But you can tell that I'm animated and I've been very stimulated by the debate today, so thank you very much.
I think you meant women and girls and boys. Just one or two comments really, rather than a question. Pete Saunders from the National Association for People Abused in Childhood. To answer your question as to why don't we do this no-brainer, one of the answers, and I'm sure we've all heard it here many times, is, well, I was beaten as a kid and it never did me any harm. How often have we heard that? And my response to that is, well, I was beaten as a child and it certainly did do me a lot of harm. And anybody wanted to come down to NAPAC and listening to some of the calls that we get from people every day talking about the beatings they took as a child, often decades ago, that they still haven't got over, they're very welcome to come down. Two other minor points. One was I was having lunch with my son today, who grew up without violence in his life, thank God, and can't contemplate why anybody would want to hit a child in the first place. And he was talking about his many friends now who have children and who are bringing them up without violence and without hitting. And so I think there are a lot of young people now who are leading the way, and the government need to know that they're actually lagging dangerously behind in all this, but I do stress dangerously. And the other point is a bit of an advert here for a current NAPAC campaign is, everybody here, I wonder if you're aware of the fact that if a child is being abused, any form of abuse, in an institutional setting, such as a school or a care home or a hospital, think of Jimmy Savile, is there a legal requirement, if somebody witnesses that, to actually report it? The answer, amazingly, is no. And we've got to get that changed as well. So anybody here, and I collared, sorry, I do go on a bit, sorry, I collared a government minister the other day. I happened to be in that place down the road in Westminster. And I said to her, you know, shouldn't we introduce mandatory reporting for abuse within regulated institutions, they're called? And she said, no, because they've got a duty to report this. I said, they've got a duty, but the duty is not a legal obligation. And she rolled her eyes and kind of walked away. So that's kind of what we're this old attitude is what we're up against, but I look to young people to lead the way.
Well, I think that really brings us to the end of our question and answer session, and I think it's for Sir Graham to conclude this really splendid evening. Can we just back again?
I can be brief. Firstly, thank you for being with us and for your participation. Particularly, we owe a debt to both Anne and Peter for the very cogent way in which they assembled their arguments. It is not a domain in which I have any personal knowledge other than as a parent, but I find your arguments so persuasive. Politicians are obtuse. But I have the feeling that progress is being made. I have been a great admirer, as a New Zealander, admirer of New Zealand over many years, because it has a very strong track record of doing the right thing sooner than many others. Let us hope that on this occasion the model there will be pursued with vigour in Wales, and that all of us will do everything we can in our personal ways to encourage the fight. So thank you all. We would be delighted as part of the evening if you would join us for a little refreshment before you pick your way out into the inclement weather that awaits you. Thank you. And thanks.